Moi, Michel, je ne t'entends pas. Est-ce que vous m'entendez quand je parle?
Oui, je t'entends, mais je n'entends pas Michel.
Fabien, tu parles? Tu peux me dire?
Oui, on vous entend, mais on place tous nos micros en mute.
Mais par contre, j'entends pas Michel. Ouais, mais j'entends pas Michel, alors je vais me...
C'est normal.
Déconnecter, me reconnecter, je pense. Vous entendez Michel, vous?
On commence?
Ah, c'est bon, c'est bon.
Michel, tu vas attendre 2 minutes.
Ah oui, d'accord. Okay. Hello, everybody. We're happy to see you attending in so big number to our conference. We are just waiting for 2 minutes in order that everybody can join, and we will start. So now it's time to start. Thank you very much to participate to our discussion on the impact of the COVID crisis on contracts and international contracts. We try to give a global answer to this global crisis. And for that, we have all the members of our network which are active. First, in Asia, we have Zhen Wang from Shanghai and my vascular team from Hong Kong. From Brazil, we have Guilherme Pogliari from Sao Paulo and Belo Horizonte. From Belgium, we have Jean-Nicolas Gossas. From India, we have Edouard Elio and Fabien Gagnero, who are also partner in the Paris office. And for Morocco, we have Ali Bougrin, who is partner of French firm in Paris and also in charge of the Morocco office. And I'm here as moderator, Michel Ponsard, and also to speak about France and French partner of our network. So we thought that it could be interesting to see what happened in different countries. We tried to keep a global approach, of course, and we will stick on very actual, very practical questions. One phase is during what you can call the lockdown period, what happened during the lockdown period, and the other one are linked to what will happen at the end of this lockdown period. So there will be the two parts of our discussion. Just before starting, some practical recommendation. First, to ask you, if possible, to put your micro on mute to avoid to hear noises. If you have any question, you can send mails to us, and we will address those questions at the end of our seminar. And of course, after this webinar, we will be in a position to send to you, for each jurisdiction, a kind of sum up of all the questions we have addressed. So the first one is a very simple question for a party possible to stop payments during the lockdown period. Ali Bougrin will give his view on this question. Thank you, Michel.
By principle, companies are not allowed to stop payment to the other party, unless, of course, the party negotiates and reach an agreement on this subject. However, two situations should be distinguished. Whether or not in your jurisdictions, the government has adopted specific measures related to the COVID-19 crisis. In France, the government has taken measures in this respect. We can mention, for example, the postponement of rents, water, gas, and electricity bills for small companies and PME. In the field of tourism, event, and culture, the cancellation during the administrative period of closure of rent and charge for small businesses, and also the establishment of a legally protected period during which the penalty and termination clauses are neutralized. When we compare this situation to other countries, for example, in Africa and especially in Morocco, the government has not taken specific measures applicable to private contracts that would exempt one of the parties from its payment obligations. In these jurisdictions, governments have generally prepared and focused their effort on social and tax measures to help companies are struggling during this crisis. Therefore, in these jurisdictions, the parties have to rely either on contractual negotiations or on the existing provision of the applicable contract law. These include when the law or case law in the jurisdiction concerned allow for it, the provision for force majeure, plea of non-performance, and of course contractual enforceability. As today, we do not have sufficient insight so far in France and Morocco on the interpretation that the judge will make of the application of this text in the particular context of the COVID-19 crisis. In view of the significant potential financial consequences, we recommend to adopt the prudential approach. And we recommend that instead to rely on legal provision, to rely best in the preferred option, which is the negotiation, of course.
Thank you, Ali. And so now I wish to ask a question to Maeva Slotin. Is there any lockdown period in Hong Kong, and what is your position on this possibility to stop payment?
Thank you, Michel. No, there is no lockdown in Hong Kong. The Hong Kong government took preemptive measures very early on, at the end of January 2020, to avoid the contamination of the virus, and it has been quite efficient. Nevertheless, companies are suffering because among those measures are the restrictions to visitors in Hong Kong, and Hong Kong is heavily reliant on visitors. And of course, since mid-March, the various lockdowns measures have also heavily impacted the companies in Hong Kong. So many of our clients are asking exactly the same questions, especially regarding salaries. And the answer is similar to the one given by Ali. Basically, salaries and payment to suppliers remain due according to the terms. There are strong sanctions in case salaries are not paid according to their terms. And the best way is indeed negotiation. I will just give you a short example of what has been done by many companies in Hong Kong anticipating a reduction in their activity. It is to negotiate with all their staff the same reduction of salaries, 20 to 50%, on a definite period of time, which for some companies extends up to September. This is contractual, meaning that some employees may opt out, which has the effect of forcing the companies either to make an exception or more likely to dismiss this employee. Thank you.
Except in certain cases, as usual, it's not possible to stop the payment. What is the situation if you want to postpone a payment? Maybe Zen Wang from Shanghai can give us a view of what happened in China now?
Yes. The answer is yes. In China, the possibility is based on the acceptance or not the COVID-19 as force measure. In fact, on February of this year, Legal Affairs Committee of China National People's Congress confirmed that COVID-19 answer all nature of force measures. That means this is an even enforceable, unavoidable, and unsurmountable. So there's no a legal regulation or law, but this is a confirmation from the Chinese higher authority. Based on this confirmation, many courts, high court, several provinces, published some guideline for the practice. Even they details that if late payment by party of a contract due to this fact, for example, for a lease contract, if tenant refuse delay this payment, and the landlord would terminate contract, the court should not support the claim for termination of the contract. So this is a lot of case in China of this nature, and in most cases the payment may be postponed in practice.
Thank you, Zen. Is it the same in Belgium, Jean-Nicolas?
Well, in Belgium, we have some special measures taken by the government, and we have in Belgium royal decrees, and one of the royal decrees, it is the Royal Decree 15, provides that temporary current contracts cannot be terminated due to default of payments. This is in fact an authorization of postponing payments. Now, independently of this royal decree and the existing terms, contractual terms, the possibility of postponing payments depends if the COVID-19 situation is evidenced as a force majeure. If it is, one of the consequences is the suspension of the contract. If we have a suspension of the contract, then the possibility of postponing payments should be possible.
Thank you, Jean-Nicolas. So to say a quick word also in France, as you know, after the law of 23 of March, we have some orders taken by the government, and one of the orders focus on certain provision of the contract, like a penalty clause or termination clause, performance of the contract. And for those kind of clause, the order 2020-306, which has been amended by the order 2020-427, provide that the time of the lockdown period will not be taken into account in the normal term. For example, if the payment starts before the lockdown period, which is between 12th of March and 24th of June, if someone provides that a payment is due for a penalty clause because of non-performance of the contract on the 10th of March, which is 2 days before the starting of the lockdown period, then if it gives 10 days, you will have 8 days after the end of the lockdown period to pay before being obliged to be in the situation of the penalty clause, which is 2 of July instead, of course, of 20th of March, because 20th March is in the lockdown period. In the same way, when you have this kind of obligation during the lockdown period, not before, the time provided for the performance is postponed after the end of the lockdown period. So, for example, if on the 20th of March you give 10 days to another party to perform its obligation, you will have to calculate those 10 days after the end of the lockdown period, which leads to 4th of July. And by the end, and it's general performance of obligation. It's not like in Belgium, focusing on payments. It's for all the obligation. And the last provision about this postponement is about contract, which occurs after the end, obligation, which occurs after the end of the lockdown period. Let's imagine a contract which is signed on the 1st of March, and there is an obligation of delivery 6 months later, which is 1st of September. You will take into account the lockdown period and postpone the term provided, excuse me. So it means that instead of the 1st of September to deliver the good, you can deliver it on the 12th of December, taking into account all the duration. So there is a postponement, but then this postponement doesn't mean that there is no liability, of course, if you don't perform your obligation at the end of this term. So that is a little focus on France. Let's continue. We have spoken about stopping payments, postponement of payments. Does it mean that it is compulsory or advisable to renegotiate the contracts? And it will be very interesting to hear Guilherme about that, because I don't know also if in Brazil you have a lockdown period, and how do you manage the situation?
Bonjour, Michel. Yeah, indeed. It is advisable to always try to settle any difference in any situation, especially now. It depends on how the negotiation should be and how desirable they are on on each contract and on each force majeure provision in any specific contract. For instance, in Brazil, even if you don't have a force majeure clause in your contract, the force majeure is still applicable. You can only avoid force majeure provisions here if you expressly state that in the contract. If the force majeure situation is declared by one party and the provisions of the contract are enough for both parties to accommodate their current needs, okay, but what we have been seeing is that in many cases, both parties are affected by force majeure at the same time. So usually the contract was not designed, was not thought for that purpose. In that sense, it is advisable to renegotiate in good faith the contracts, to sit down and to try to accommodate the other party's needs and put your own expectations on the table to try to reach a settlement. It's important, though, that one party does not overstates its damages in the situation. fairness and good faith are paramount, are very important in this situation that we are having right now. So renegotiating the contracts should have that always in mind. We have seen, for instance, we have a question here from Christophe Pailuso about rental contracts of equipment. A company is stopping to pay rents on his equipment in Angola. What happens in this case is that his company is small and the company that stopped paying the rent is much bigger. So it is advisable to negotiate the contract, because not only the company that's renting the equipment is in force majeure. Christophe's company is always also in force majeure situation, and with the aggravation that it is a smaller company. So one party cannot take the crisis for itself and say, oh, I'm affected by force majeure, I'm not fulfilling my obligations, and ask for the other party to fulfill everything that it should under the contract. So the exception of the exception on diplomatic contractors applies here, meaning that one party, or he's saying now that no force majeure in Angola. So that's a situation I have to analyze in detail then, because if you have, but even though if there's no force majeure, they couldn't stop paying. Okay, they have to do it under contract provision or under legal provision. Well, so in cases like this, you have to take into consideration, as I said, the situation of both parties, not only one. One party cannot take the crisis all for itself and say to the other party, because it's stronger, it's bigger, or it has leverage in the contract, tell the other party, I'm excused for my obligations and you are not. Even if the legislation doesn't say that, international contract principles state that the reciprocity and balance should be main guidelines in interpreting a contract. So one party cannot excuse itself and ask the other party to fulfill all its obligations. So it's definitely a situation you can negotiate. As for it being compulsory, Michelle, it's not compulsory because it is a negotiation. The party can refuse, but it is highly advisable to renegotiate contracts in this situation, taking into consideration both sides and trying to accommodate all the parties' needs, everybody losing a little bit, so one party doesn't lose it all. Okay, everybody's losing, everybody is having damage in this situation, and we have to be mindful of that when negotiating and when dealing with contract crisis.
Thank you, Guillaume. So the question, because the situation of Brazil is specific, is it different in France, Ali? Do you, because of this postponement, do you recommend to negotiate or not the contract?
Of course, I fully agree with what Guillaume have said. I will just add that in France, because of the introduction of the legally protected period, which neutralizes the effect of penalty and termination clauses, it is likely that at the end of this period, many difficult situations will arise. Indeed, at the end of this period, all the obligations of the party are maintained and become effective again. So the contractor who have been imposed suspension of payment by application of the law and not by negotiations will be allowed to request immediate payment and, if necessary, to implement penalty termination clause, even though the other party face a difficult time. That's why, in our opinion, the option of negotiation is preferable and should always be recommended before to rely on the legal provision that can impose in France a postponement of payment.
Thank you, Ali. So to continue on those enforceability of provision, next question is, okay, if I have a penalty clause will it apply? Will it be enforceable or not during this period? Fabien, do you want to say us a word about that?
Yes, absolutely, Michel. See, the problem would be, depending on your jurisdiction and the applicable law, the answer would be quite different. If we have a look at India, penalty clauses which are valid under Indian laws would remain so. There is absolutely no scheme that says that the penalty clauses and the liquidated damages that you are owed to pay in case you don't deliver in time or as per the right conditions would be waived during that period. So that means that anything that is any penalty clauses that are valid under Indian law will continue to apply, and that is, of course, subject to the fact that you can't demonstrate that force majeure situation has happened or frustration of contract has happened if you can prove that, as we could detail later on. Now, if you come back to French law, that is quite different indeed, as you mentioned before, as Ali mentioned before as well. The special orders that were passed by French government have put on abeyance, have put on hold the effect of any penalty clauses that could apply to a contract during the legally protected period. That is to say that if you have a penalty clause that was supposed to be activated during that period that we are in right now, it would be deemed not to be activated, not to be in effect till the end of that legally protected period. That is till the end of June 2020.
Thank you, Fabien. I don't know if Jean-Nicolas, you have
yes, maybe to make the link, in Belgium we have also a special measure, and this is principally applicable to the agreements obtained by public tender by the federal state. The federal state announced that temporarily there will be no application of penalties and sanctions, but what's very important is that it's submitted to a formality. This means that we have to announce and to formally and timely notificate the problem to have the benefit of this temporary exemption.
Jean-Nicolas, for France, we mentioned already this postponement for penalty clause, which means that the penalty will have to be paid after, in general, I won't come back to the example, after the end of the lockdown period. Maybe Maeva, in Hong Kong, there are some specific situation, or?
Maeva, you are on mute.
You are on mute, Maeva.
Sorry. Unfortunately, we don't have anything similar to Belgium provisions just mentioned by Jean-Nicolas, which means that penalty clauses applies, late interests apply, and the possibility, and in case one party doesn't comply with its duties, there is always a possibility, but not an obligation for the other one to terminate the agreement. So, so if you don't comply with your contractual obligations, expect contractual remedies and possibly also common law remedies in Hong Kong.
Thank you, Maeva, and maybe I will. You will keep the floor for the following question, which is, we have spoken about payments a lot, about performance of obligation, but does it mean that it's still possible to terminate or not a contract during this lockdown period? Maeva?
Yes. Well, there is no lockdown in Hong Kong, as I said already previously. So the usual provisions would apply, meaning that yes, you can terminate your contract you can terminate according to the clauses of the contract. So, which means for fixed term contracts, like commercial leases, it's a very difficult situation for tenant. Basically, they are locked until the term of the contract, with a duty to pay a rent, which has been agreed under very different economic circumstances. So that's the first point. And in this situation, the best advice is negotiate, what we've said before. For contracts which are not fixed-term contract, parties need to look at the termination provisions. Typical termination provision in Hong Kong will have two sub-clauses. One is for termination without cause, which is usually possible with a notice period, which is usually short in Hong Kong contracts, 2 to 3 months. Of course, it may be longer. That's one thing to consider. Alternatively, well, and the other subclause is termination with cause, which is usually due to the other party non-complying, for instance, not making the payments. Service provider can terminate an agreement if the client is not paying. So this will be the main provision. If there is nothing in the agreement, it's a difficult situation. The doctrine of repudiatory breach can be of assistance, but it implies that the other party is not performing at all. And in this case, you may consider that the contract is terminated. The conclusion is that, yes, you can terminate a contract during this period with the same caveats as usual. But the recommendation on how to protect yourself now is even stronger than usually. Communicate and try to initiate negotiations.
Thank you, Maeva. So the question is also raised, of course, and addressed in France when we have those provisions. So is it possible in France to terminate an agreement with this Article 4 of the order that I mentioned before? What is important to bear in mind is that all the provision which provides those postponements is based on non-performance of an obligation. So what is not possible during the lockdown period is to terminate an agreement because of the non-performance of the obligation by the other party. If you're not in a situation of non-performance, nothing prevents one party to decide to terminate. As for example, Maeva mentioned, if you are in a contract with an indefinite term period, it means that you can terminate for no reason, you do not have to justify it. When you want, subject to give a sufficient notice period, that's it. So you can, even in the notice period, in the lockdown period, you can terminate an agreement. And it means also that all the provision we have in France about public order for certain termination notice are in force, and that if a party decides to terminate an agreement before the lockdown period, it will, with a certain notice period, it will play its role during this period. And to stress even more the fact that it was decided to maintain this possibility to terminate the agreement, we have in this order 2023-6 an Article 5, which even enable a party which does not take the opportunity to refuse to renew an agreement or to terminate an agreement in the lockdown period to have an additional term which lasts until 24 August of that year to decide not to renew or to terminate. So it's the fact that the French legislator focus on non-performance of agreement, which is the most important. And after all those provisions, it seems to us important also to raise a question about acquisition, because we can imagine that acquisition are very impacted by this situation, and mainly about what we call MAC provision in acquisition, material adverse change. Edouard, can you tell us your view on that? Is MAC provision applicable?
Yes, sure. Thank you, Michel. So what can we say about MAC provision? So typically the absence of occurrence of a material adverse change, so what we call MAC event, is a condition closing under an acquisition agreement, an SPA, and a condition to funding under facility agreement, bilateral agreement, or syndicated loan, for instance. So practically the implementation of a MAC clause will depend on its term and condition. Indeed, force majeure is a situation which is foreseen by the law in most European countries, but the MAC clause is a pure invention of the M&A practice. So everything is a question of wording regarding the application of MAC provision. That being said, a standard MAC provision generally includes three parts. This is a market practice in the M&A sector. First, a MAC, so material adverse change, is defined as an event, development, or condition having or reasonably likely to have a material adverse effect on the business, the financial conditions, or the results of the target, so the company which is being acquired. Second, the provision typically exclude specific events such as general economic downturns, conditions existing generally within the company's industries, and other broad categories of market credit condition, what we call macroeconomic event. Third, the purchaser should not have been aware of the events prior to the signing of the agreement. So it's a little bit like for the force majeure. The knowledge of the situation by the parties is paramount in the appreciation of the clause. So it's a question of timing, meaning if the purchaser was aware or should have been aware of the COVID situation before the signing, the clause obviously will not apply because the purchaser knew before the signing. That being said, it's obvious that the measures taken by the governments are likely to negatively and adversely affect any company's business, and that therefore the purchaser can decide not to finalize the agreement depending on the financial consequences for the target. This is a broad interpretation. So it depends on the target's business and activities, because the interpretation will be different for target in the transport business or leisure business, for instance, and in the pharmaceutical business, for instance. One is deeply impacted by the COVID situation, and the other one is not affected as much. So in case of litigation, because there will be litigation regarding this question, and it's already the case in several countries, including in the US, two main issues will arise according to the case law available. So the first is to know whether the COVID, which appeared in China at the end of 2019, was imprevisible or not for the purchaser. So on a worldwide basis, the World Health Organization declared the COVID a pandemic at the end of January 2020. And in France, the health emergency was declared on mid-March 2020. So everything will depend on the signing date of the agreement. Second issue in case of litigation regarding the materiality threshold, because the clause applies if the target's business is materially affected. The case law generally requires that the change was material and had durational significance. A material change practically is one that is severe, not a blip. So for instance, a decline in earnings of around 30%, or the same for the turnover of the company, and for a period which is measured not in months, but in years. So we need a severe materiality for the clause to apply. That being said, maybe Ali will talk about that. We have already adopted the wording of our MAC clause to adapt to the current situation.
As an M&A lawyer, as it was said, MAC clause are practice markets. I mean, in every SPA, you will find normally a MAC clause in order to prevent the consequences of adverse changes. That's why, as it was said, within our firm, we have conducted a review of our usual template of MAC clause. Indeed, given the uncertainty of the durations of this crisis and the risk that a similar crisis may occur again, we have adjusted the wording of the clause. The purpose is to be sure that we will avoid inclusion of the scope of the MAC clause of the COVID-19 or similar crisis. I think the approach to review the clause of your important contract is really, really important. It's not just, in our opinion, to have to be limited to the MAC clause, but to all the clauses applicable in your contract, such as force majeure, hardship clause, that have to be reviewed in the current context of the COVID-19. So we recommend, especially for the new contracts that you will have to sign in the future, to have a particular attention to this kind of clause.
Thank you, Ali. Maybe, Maeva, you want to say a word also for those specific provisions of clause in Hong Kong?
Yes, just a quick word about my own experience of negotiating the carve-out of the, COVID-19 related restrictions in a MAC clause mid-March, just before the French government announced the lockdown measures. The transaction was between Hong Kong and a French company, and the target, the owner of shares in the target company was willing to have this carve-out, and the potential buyer was not, and they couldn't agree, and the transaction didn't go ahead. What I see now in the transactions which happen, the new ones which are being negotiated at least, is that indeed it's very important to include a new drafting, but at the same time the parties have investors and have integrated this crisis, and they are not really, investors are not really looking for a potential exit due to the crisis. It's integrated that it's here for a period of time, and it seems that some investors are now seeing opportunities actually.
So another practical question that we have from our clients is the following: what happens if the renewal of an agreement occurs during the lockdown period? Am I obliged to renew it, or do I have the possibility to refuse? Jean-Nicolas, what happens in Belgium for that?
Well, the first thing is to make a distinction between the automatic renewal clauses or not. Now, most frequently situation is certainly the automatic renewal clauses, and the non-renewal is certainly a question of timely and prior notification of determination. Depending on the terms of wording of the agreement, the lockdown period has normally no influence on the automatic renewal. Now, with our specific situation of COVID, force majeure will have an influence, certainly if the force majeure arrives before renewal. This, what I wanted to say is that if the conditions of force majeure are met, the consequences of the force majeure could be the dissolving of the contract, dissolving before the term of renewal. This means that in this case, the question of renewal is only theoretical.
Thank you very much, Jean-Nicolas. In France, as I have said, not only you're not required to renew, but even there is the possibility to have an extended period to decide to renew or not, since the order 2020-306 from 25 March 2020 provide that the party will have until the 24th of August to decide to renew or not an agreement if this renewal term occurs during the lockdown period. So it's even an extension. It's even a possibility not to renew. Now, of course, there is another tricky issue in this period, in this complicated period, which is what can I do if a party wants to take advantage of this exceptional circumstance to refuse to perform its obligation or to create a kind of imbalance in the relation between the parties. What is your view, Guilherme, about this tricky situation? We don't hear you. We don't hear you. You're on mute.
Sorry.
Yes.
Okay, thank you, Michel. In the exceptional circumstances that we are living right now, we have many parties issuing force majeure declarations, being unable to perform their contracts, but in a few occasions we have noticed that parties that were not satisfied with a contract using this crisis as an opportunity to bail out or to get more favorable terms out of a contract. Well, at least here in Brazil, we have, when you declare a force majeure situation in your contract, you have to prove to the other party how is it affecting you, and it can only it can only impact the contract in exact extent that is truly demonstrated by the party declaring force majeure. So if a party feels that the other party is trying to take advantage of the situation, okay, by declaring force majeure in a case that does not seem very clear that is impacting the contract, the innocent party, the non-declaring party, should ask for proof of the force majeure condition, for proof of the impacts that the party is suffering, and demand that the other party takes all measures it can, all appropriate measures to mitigate the damages and the impacts in the contract. Okay, only then can the force majeure be properly accepted by the other party, and it can be, of course, this is absent from clear guidelines in the contract, because in Brazil, like I said, the force majeure arises from the law itself, so it doesn't have to be in a contract, but there are contracts which define clearly what the force majeure steps should be. In this case are easier, but when you don't have that, you just have a general force majeure provision, we have to apply what I said. Prove the impacts that the force majeure is having in a contract, take actions to mitigate all damages and all impacts to the other party, okay, and limit the consequences of the force majeure strictly to the proven impacts in your contract. And as said before here, it is very important to declare force majeure as soon as possible in order for it to be effective in in a situation. I wonder if in any country that you work at, is it different, or is the same basic principle that I said applies to other countries? Ali?
Yes.
Sorry,
Yes.
I was asking if what I'm saying, what I said here about the parties taking advantage, and that the declaring party should make all efforts to prove the impacts. The declaring party should prove the impacts of force majeure in its contract, should take all actions to mitigate damages. I asked if this is perhaps differently in other jurisdictions, or in your experience, this is a general principle applied internationally.
Yes, of course, I think it's a general principle, because we can rely on two basic facts. You have the general good faith principle applicable in every jurisdiction. So when you use a clause of a contract, you activate a clause of a contract, such of a clause of force majeure, of a terminations, to bail out of a contract, you have to activate it in good faith. Meaning, if you can be challenged if you activate such clause in bad faith by the other party, and then you will have at the end of the day in front of a judge to evidence that you have activated in good faith your termination clause or your clause of force majeure, and you will have to provide every details that motivates in good faith the activation of the clause. So it's something to not have not lost in your mind that indeed we are currently facing in very, very, very extraordinary period, but the general principle of the law, such as a good faith, are indeed still in effect, and will have some application in the future. And we foresee to have several litigation in the next future regarding termination clauses that have been activated in the context of the COVID-19, even though during the lockdown period, but because in some jurisdictions, such as Morocco, for instance, you can still introduce, in case of when the situation of one contractor is jeopardized by the bad faith of the other party, and for instance, put the company in a very difficult situations, and for instance, in a situation where the company will be not able to, for example, pay its employee, you can introduce a summary proceeding during the lockdown period to enforce your contract, even the other party have tried to terminate your contract. So to make a general answer, yes, of course, this is a general answer in many jurisdictions in Europe and as well in Africa.
Thank you very much, Ali. And of course, in this extent, a critical question is it possible to go before court to make an action in order to protect your rights? Edouard, do you want to tell us what is the situation in France now?
Yeah. So thank you, Michel. From a litigation perspective, it is not impossible in principle, but practically quite difficult. I will stick to commercial litigations for the presentation. So on March 14, 2020, a circular was adopted concerning pending criminal and civil litigation, and they are all postponed for listed matter pending matters, and some hearings were also plainly cancelled. That being said, whenever possible and in commercial litigations, hearings are currently conducted through video conference like Skype or Zoom. For instance, this morning we had a hearing before the Commercial Court of Paris, and it was held by Zoom with all the parties and the lawyers present. and we will have the decision of the court on May 22. So it can work. This is for pending matters. For new matters, the activity is mostly limited to emergency cases, and for the time being, only commercial litigation which are extremely urgent can be filed, mainly emergency proceedings. It being specified that the urgency requirement is assessed in the current circumstances with greater scrutiny than in normal times by the judge. But for emergency proceeding, it is possible. As of date, it is still possible to file an insolvency application or request the appointment of a receiver in case of financial difficulties, which is quite common for the time being in France and in Europe. Hearings are held by video conference as well, and many bankruptcy proceedings have been opened over the last month, for instance, before every commercial court in France. It works because we have no choice. When a company cannot pay his employee anymore, we have no choice. As the deconfinement approaches, it is now also possible to file a regular claim before the commercial court for hearing listed at the end of May before all commercial court in France. This is what we can say about litigation in the current context. Michel.
Thank you very much, Edouard. And now, may we ask to Jean-Nicolas the situation of litigation in Belgium?
Yes, well, generally we can say that it remains possible to introduce the action. Now, several royal decrees has been taken, and a certain decrees concerned the extension of the delays and other measures were taken. For example, the temporary, there is no possibility to declaration of bankruptcy. It's not for the litigation, it's not like in France. I have not knowledge of Zoom procedures, but the royal decrees try to promote the written procedures, but introducing an action is still possible.
Then what happened in China about litigation? Is it possible to continue to litigate normally?
Yes, in China, the litigation has never been stopped. The first reason is in China, except one city, Wuhan, which was in a strict lockdown situation. Other cities and other provinces were in some situation, in some not very strict lockdown situation. So the administration and courts and the tribunals continue to work maybe with a slow rhythm, but it's not stopped. The second reason is even before COVID-19, the Chinese government promotes the online trade for the commercial and the civil cases. So after in the end of February, the Supreme Court of China has published documents for promoting more the online litigation resolution. Is from the registration of the cases, the exchange of the evidences, hearing online, and a decision, even the services. So they would like to promote a full application of the online solution. therefore, this during the absolute relative lockdown situation in China, the court and the tribunal do not cess their activities. So it's maybe some slow down rhythm, but it's not stopped at all.
Thank you very much. So this is where it's easier to litigate, so it's an important possibility. So we have focused on what could happen during this lockdown period, but the other very important question is what will happen after the end of the lockdown period. And then we have, of course, to go to the issue of liability. When we spoke about postponement, about stop to pay, the question is, what is your liability if it is or not a force majeure event? And we want to focus, of course, on this issue of force majeure. Jean-Nicolas, what is your thought about the possibility to consider that in such situation we are or not in a force majeure event?
Well, the first thing is to see if the COVID-19 situation is or not qualified as force majeure. In Belgium, we have to look to the measures taken by the authorities to see if these measures has or not the conditions of force majeure. This means that in absence of specific contractual clauses, we have to analyze if the situation has all the conditions of applications of force majeure. Maybe to summarize, to analyze if force majeure exists or not, there are three conditions to be met. The first condition is that the situation is not accountable to the party who that invokes it. Second condition is the situation unforeseeable? And third, is there an impossibility to perform or to carry out the contractual obligations? If these conditions are met, it's only a consequence for the future, and the consequence of force majeure in the future on the agreement can be or dissolving the agreement if force majeure has a definitive consequence, or it's the suspension of the obligation if the force majeure situation is temporary. If really force majeure conditions are met based on the doctrine of the risk, a creditor could not claim anything to the other party. But the notion of force majeure, we heard it before, and I think it's a central principle for analyzing all the situations.
Thank you, Jean-Nicolas. In Hong Kong, Maeva, is such situation be considered as a force majeure event?
Well, in Hong Kong, force majeure can only be considered if there is a clause in the contract. That's the first main point. And the first effect of force majeure, in case you could argue based on the drafting of your clause that there is a force majeure event, is a suspension of the obligation. And it's only after a certain period of time that the parties may decide that it should be actually terminated. But based on the precedent situation of SARS in 2003, where we had one case law where tenant who had been hospitalized for period of time, and he was using the force majeure clause in the tenancy agreement to argue that he was not liable to pay the rent during this period. Basically, the judge considered that the fact that basically the outbreak of SARS may arguably be an unforeseeable event. Okay, so that's one of the conditions for the force majeure. However, such supervening event did not, in the judgment, according to the judge, significantly change the nature of the outstanding contractual rights or obligation from what the parties could reasonably have contemplated at the time of the execution of the tenancy agreement. So it was ruled out, and I think the key point is that the obligation had become more onerous, yes, but not impossible.
Thank you, Maeva. So China is very close to Hong Kong.
No.
So it's the same situation, I imagine?
No, it's very different, because in China the force majeure is legal. Is clearly defined in contract law and recognized by the court and the tribunal, even if there is no force majeure clauses in the contract. In 2003, when China will face into the SARS situation, the Supreme Court has published some interpretation confirming that the epidemic at that time was considered as a force majeure. This time, there's no new regulation or new interpretation from the court, from the Supreme Court, but the same principle and the same practice has been accepted by the court. So in this time, in this year, the COVID-19 may be considered as, if any non-performance of the contract may be considered as a force majeure. But the consideration is never automatic, like what to say by Jean-Nicolas, it should be analyzed in a case-by-case basis. Usually, it should analyze if the outbreak or is lead automatically or to some non-performance of the contract, or lead to failure to perform a contract, or there is some negligence or some fault from the claiming party. It should be analyzed as well if the failure in performance of the contract is result from delay. They want to looking for if in no performance there's some fault or some negligence, improper performance by a party. So and it will analyze also if there's some government orders or government decision may lead to non-performance of the contract. So it's not automatic. It is depend to each region and each province where the epidemic situation is different, and the measure are different also. the same principle is applied to bankrupt of a company to know if there is some liability of the company in the bankrupt or is purely and totally due to epidemic situation.
Thank you, then. Two last questions before opening the door to the discussion. If it's not force majeure, is there any other ground on which a party can rely to try to lessen his liability? What is your view, Fabien?
Well, Michel, that is the tricky question, isn't it? If you cannot rely on force majeure, then the first check that you ought to do would be to have a thorough analysis of a contract and the clauses that may offer some contractual remedy, like an obligation to renegotiate, for instance, a hardship clause or such. Then there are, depending on where you are, there are a couple of tools that you can also use. In India, we can think of something that we call the Doctrine of Frustration, which basically stipulates under the Indian Contract Act that if the contract is made impossible by the circumstances that were not envisioned at the time of the contract's execution, you may terminate the contract for that purpose. So that could be a way to find a way out. Now the thing is to lesser your liability in a context where you cannot perform and you cannot claim that you are under force majeure circumstance. Well, I'm going to go back to what Guillaume said earlier. I mean, your best option in that situation could be, apart from the contract, apart from whatever remedy you may have under law, under the contract itself, the best option for you is also to deepen the dialogue with your creditor, with the other party in general. So to notify any kind of trouble, any kind of difficulty that you may have in performing the contract, and also to respect at all time, as much as possible, the general principle that Guillaume also mentioned, that is quite common, I think, to all our jurisdiction, that is to try to mitigate as much as possible the damage that your non-performance could create. Now, interestingly, that duty to mitigate the damage could not only be applied to the debtor, but also to the creditor of the obligation itself. If you take an example that has to do with anything that is perishable, if you claim that your debtor has created a problem because he did not perform his obligation and the goods are now perished and they cannot be used anymore, you also have, as a creditor who may, for instance, be in custody of such goods, you may have a duty to protect those from being perished eventually.
Thank you, Fabien. Jean-Nicolas?
Yes, maybe a general advice is that when we have troubles of this COVID situation, it's very important to notify the situation, the effects, and to detail the risk to the other party. It's very interesting because this shows or gives the evidence of the good faith. Now, good faith is important not only to create a negotiation, but if we are going to litigation, good faith is a principle which can influence the decision of the jurisdiction. I think, therefore, the principal advice is inform the other party.
Nicolas. So now we're arriving to the end, and of course the question for a lot of countries which are a little bit in the middle, I hope close to the end, but a little bit in the middle of the crisis, is what risk can we foresee at the end of the lockdown period? And it's interesting, I think, to ask the question to Zen, because China seems to leave a little bit the health crisis. What is your view on those risks, Zen? Do you have any experience with that now?
in our practice, we have seen after the period, the most serious period. Now it's the situation is come to normal, and the renegotiation of the contract restart. It's most of the commercial issues, of course. For example, the increase of the price. The contract is in performance, in its validity, and it's not terminated. So, but some party claim some increase of the price to continue to the contract. Other things is the products. The products subject of the contract no more available. That means some factory in China, when they restart their production, they decided to no more produce some products in their factory. The third situation is for the distribution contract, where there is some minimum quantity clothes or target clothes. They, of course, they revert to the partner and to modify this kind of the clothes to reduce, of course, their targets and the target of the country. Mainly this kind of discussion for the contract.
Thank you. Then, Guilherme, what is your view on the risk following the end of the lockdown period?
Yes. Well, one risk I foresee is that many unsolved issues, the life will start going back to normal, and many unsolved issues will arise and impact all at once the companies who wish to resume their relationships that were stopped in this crisis. So I expect a large number of litigation after this, because some parties will not be happy with the conditions that will be imposed or put by the other party to resume the contract or to mitigate the damages that the parties have suffered. And I believe we will be having discussions. This is a very new situation. Although force majeure is a very common case in doctrine and in day-to-day life, force majeure by a worldwide pandemic, it's unforeseen. I mean, it's something that we haven't seen in about 100 years. So it's a new territory for our jurisprudence, for legal systems. So I expect some conflicts to arise that are dormant now because of the crisis to arise and be taken not only to negotiations to each party, but also to the courts. I would like the opportunity to answer one question that is related to this by Mr. Julien Chevy. He asks he says that one party has an obligation to the end of this year and is already declaring that it won't be able to performance because it's been impacted. And he said, well, but the effects of the lockdown should be over by the end of the year. Why can't he perform his obligation in due time if he has until the end of the year? Well, the answer, I believe, is he has to prove it to you. He has to prove that his production, I don't know which kind of relationship you are talking about, is a purchase supplier. But if he can prove, the other party can prove that his production, his activities are being impacted in order to delay all his deliveries and pushing back deliveries further, even after the lockdown period ends, then he has a case in postponing your deadline. But he has to prove it to you. He has to prove that his company is being impacted, and even after the lockdown period ends, he cannot deliver the goods in time due to the lockdown period. Okay, this has to be truly demonstrated to you, and he can only delay the goods in the exact measure that his impacts are proven to you. Okay.
Thank you, Guilherme. Ali, your view on
yes, just before that, just to specify, to add something to the answer to the Julien Chevy questions. The answers that I've mentioned, Guilherme, apply to your specific cases, because I've seen in your questions that your question was related to a year-end discount clause, but the general answer is the same that Guilherme applied. It applied to an obligation related to deliveries of goods or to the application of a year-end discount clause. It was just preliminary things. Yes, talking about the risk related to the COVID-19 crisis and what we can foresee after this period, I think I have 3 topics that I want to address. First of all, I think it's the same for Europe or in Africa. We will unfortunately have to face a lot of litigation related to contracts, to interpretation of contracts, whether or not the force majeure was evidenced or was here in reality or was justified to terminate a contract or exempt a party to perform its obligations. And it will open a period of uncertainty. As Guilherme said, we have not so much precedent on this specific issue. So we will see in the coming weeks and months what the judge will rule on this specific issue. The second topic that I want to address is we will unfortunately expect to have a lot more bankruptcy proceedings that will open because of this crisis. A lot of companies have been heavily impacted by the crisis, and we expect to have a lot of companies in France and also in Africa that will be under insolvency proceeding, asking maybe for emergency measure ruled by the Chapter 11 or the equivalent in each jurisdictions. But this leads to another question, to the liability of the manager during this crisis. Because what should the manager do during this crisis? When he sees that the crisis will have a material impact on or will jeopardize the existence of the company, should he immediately introduce a bankruptcy proceeding or wait until the lockdown period to initiate those measures? That's tricky questions, and then can have an impact in the personal liability of the manager, who can be accused to have delayed some emergency measures that she will have to take in a normal time. And we could have the same question about payment of debtors, which kind of debtor that a manager should address, the rank of payments. This is some kind of question that we will, I think, face. I think, talking about my expertise, M&A we've seen that during this period, M&A transactions were really slow, and this crisis, as every crisis, will of course create opportunity in the coming months, and we maybe will see that in the future. I think there is transactions connected to potential targets for opportunities for certain companies.
Thank you, Ali. So I think we have 2 minutes before finishing our webinar. Just a word to try to sum up what we said. Thank you all, because it was a very rich contribution of each country. So I will try just to mention certain points. One is obvious. There is not a lockdown period in all jurisdictions. Maeva mentioned Hong Kong, Guilherme, Brazil, where there is no lockdown period. So it's different among the countries. And finally, if we try to have to think a little bit to it, even if in countries where you have some provision of the law about lockdown period, it's more provision about postponement of obligation. But I'm not sure that it's really changed the main issue, which is at the end of the lockdown period, are you liable or not? And this is in a certain way an answer to Joviano when he says there are different measures and temporary laws. How can I handle the negotiation? The main issue is about maybe general principle, force majeure, not everywhere, good faith, that has been mentioned, maybe improvision, adaptation of the contract, try to renegotiate. It's more an issue of general grounds. So,
Michel,
yes.
About this question of Joviano, if I may, many countries like Brazil, for instance, he's from Brazil, have a way of solving this crisis. For instance, Brazil has an introductory law to the civil code, which specifies which law is applicable to each contract. So I think it's a case-by-case analysis to see which law applies if a contract does not say the applicable law for a contract. And to conclude, for this case, there's a principle that I like by Professor Frédéric Savigny. He says that the applicable law should be the one that connects more closely to the contract. It's a principle, it's not a direct rule, but I think it's a very good start and a very good way to try to find out which law is applicable in this case.
So to continue to sum up and to stick to the basic, first things to do in such situation, of course, is to look obviously at the contractual provision of your agreement. You have to look at it and to see if it offers to you some rights and obligations. And then taking into account the fact that in a lot of jurisdictions, it will be really complicated to litigate, everybody recommends to try a renegotiation. And you may have some leverage to try to renegotiate. The first one, of course, we had that in France, but I imagine that it's the same in other countries. If a party refuses to perform its obligation, you can say, okay, you don't perform, I will not perform my obligation neither. So it's a kind of blackmail on the performance of the contract. But also, as we mentioned, at the end of the lockdown period, there will be an issue of liability. And so if a party wants to stop to perform its obligation, you will have a way to say, okay, you decide to try to take advantage of the situation now, but we will have a rendezvous at the end of the lockdown period, and you will have to pay maybe a huge amount about that. And the other leverage I think you can have to try to renegotiate is if you have, for example, an agreement with an indefinite term, you can say, anyway, I'm not happy with what you do during this period, and I will terminate the agreement after the lockdown period because I don't need any cause and I can terminate it when I want in any situation. So this is a kind of sum up of what we said. Of course, it was more deeper analysis of the situation of each country. And maybe we can go to some last questions that we have not already addressed. Maybe one about Angola. I don't know if you want to say a word, Ali. It was the first question of Christophe Payusso, who told us that he has a contract in Angola with equipment rentals. One client decided to stop to pay the daily rental rates until the situation evolves. And Christophe asked us if the company, which is what can he do against this company, which is a major company there, whereas they belong to a small company, taking into account the fact that there is no force majeure situation or case law in Angola. I don't know if
yes, I think Guilherme have begin to answer to this question, but I will just add something to see. I don't think Angola have taken specific measure applicable to private contract law. I'm not sure about that, but if it is the case, you have to check whether or not this company has the rights based on this specific measure to postpone or to stop the payments. If not, then we have to rely on the general principle to apply in Angola, which is the good faith, the execution of good faith, or the hardships. In force majeure, apparently there is no, in Angola there is no force majeure apparently, so you have to rely on the general principle of good faith. And in your particular cases, because the company is huge and a big actor of oil and gas industry, you will have more facility to demonstrate that stopping payment from the other side, even when you continue to perform the obligation, which is the rental of the equipment, caused you damages, and you can introduce and notice to the adverse party a notice to comply with its obligation of payment, subject to introduce a litigation against him. So basically, to answer to your questions, I think without the concept force majeure, you have to rely on the concept of good faith, execution of good faith of the contract, and from the fact that you described, there is maybe room for a formal notice on this ground.
Thank you, Ali. We have also a question from Bertrand Caro in France. If a rental contract was up for renewal on June 30th, 2020, will this date be also postponed by 3.5 months? Thank you. So the answer is both in the law and in the order 2020-306 that I mentioned before. You have to stick on, of course, the legally protected period. Article 4 of law of 23 March 2020 provide a period of health emergency for 2 months since the entry into force of the law, which means that it is between the 24th and the 24th of May. And the Article 5 of the order that I mentioned provide concerning this renewal term that you will be in a situation to refuse the renewal if this renewal term occurs during the legal protect legally period, which is supposed to last, according to Article 1 of the same order, between the 12th of March and the expiry of a term of 1 month after the end of the health emergency period, which means 24 June. So, subject to a deeper analysis, it seems to me that the date of 30 June, of course, is after the date of 24th, and it seems that this renewal extension period will not apply in the case you mentioned.
I agree.
I don't know if you have if there is other question. I think we have answered to all the question we have. Of course, for Julien also, as mentioned, it's an issue of renegotiation of agreement. It's clear that for all the year-end clause, the application and the analysis of those clauses will be done during the year. So it means that if you are not able, as mentioned, Guillaume and Ali, to perform for this reason, you have an argument to discuss the contract and to discuss the target, as mentioned also then in the distribution agreement in China. I don't know if there is any other question. Thank you very much for your participation to our webinar during this 1 hour and a half. We were very happy to have this opportunity to show our view on this question, and we hope to have another occasion soon to rediscuss with you. Thank you very much.
And to finish, we will send you a description for each jurisdictions addressing all the questions that we addressed today.
Thank you all. Bye-bye. Nice.
Bye-bye.
Goodbye, everybody.
Bye-bye.
Thank you. Bye-bye.
Have a good afternoon or good evening for either.